One of the most common areas of disputes between tenants and landlords comes when it's time to return the tenant's security deposit. Tenant's been in a property for a period of time, they moved out, and it's time to do the security deposit disposition process, and that is where oftentimes a dispute arises. I'm Marc Cunningham with Grace Property Management, and let me explain some of the common misconceptions, things that you should be doing if you're a landlord to ensure you're complying with the law, and things you should be doing as a tenant to ensure you're going to get the full return of your security deposit when you move out of a property. So just a couple ground rules and things to be aware of. First, these things that I'm talking about, they apply to everybody across the board. It doesn't matter if you're a third-party professional property management company like Grace Management, managing for investors, or if you are a one-person investor and you just own one little condo and you manage it yourself. All these rules apply just as much to you as it does to a large corporate landlord. It's not different for you because you self-manage a small property. It applies to everybody that way. A couple things to remember. Number one, the security deposit charged in Colorado may never exceed more than 2 times the amount of the rent. So if your rent's $1,000, the deposit cannot be more than $2,000. That has to be disclosed, obviously, in the lease. That's Colorado state law number one we need to be aware of. Now, if you're a tenant, you should also know that the lease agreement has to also disclose who is holding your security deposit. We're a third-party property management company. We get hired by investors to manage their property, but we hold those security deposits. That's disclosed in the lease agreement. So if you're a tenant, you can look at your lease, and that's going to tell you, is the deposit held by the actual owner of the property? Is it held by the property management company? But who's holding that deposit? And that's important for you to know as the tenant, because that's where your money is being held at. So how long does it take to get your deposit back? You're a tenant, you move out of a property. When should you expect to receive that deposit back, or at least a disposition of any charges? Colorado state law says that you must receive the return of the deposit or the disposition of that, the letter explaining for any charges, within 30 days of you moving out of the property, unless the lease itself states that the landlord has up to 60 days. So between no more than 30, if the lease is silent, or if the lease says, hey, we have 60 days to return it, then it's 60 days. The reason that period of time is in place is so that landlords have an opportunity to get the invoices in from vendors, from utility providers, and ensure they're properly performing that security deposit disposition. But typically landlords want to get that completed and out as quick as possible to the vacating tenant. Now, this is where the question always comes up. Well, what can I charge against the security deposit? That's what the landlords want to know. And the tenants want to know, what am I going to get back? What can be charged against me? What can't be charged against me? Well, what you can charge for, the things that are most commonly charged against a security deposit, the tenant moves out, and things that are appropriate and legal to charge for would be things like outstanding lease charges. So if the tenant paid rent short 1 month and they have a $100 rent balance outstanding, that could be charged against the security deposit that's being held on the property. Outstanding utility charges, if utilities are something that the tenant pays separately in addition to the rent. So if the tenant is renting a single family home and they pay their own water bill to the city, and the water bill always comes in arrears, it comes after the following month, there may be that final water bill that would be charged to the tenant's security deposit on that. And of course, property damage. Now, in just a minute, I'll go into more detail on property damage, what's wear and tear. But those are some things that are typically allowable under Colorado state law, and everything has to be looked at in the specifics of the situation to be charged. Now, what are some things that landlords often think they can charge for, but they really can't or shouldn't be doing that? Well, number one, and this is hopefully obvious, but no existing damage. If there was damage to the property when the tenant moved in, and that's why every tenant should receive a check-in sheet and documentation when they move into the property, so they can note and record any existing damage or problems with the property. If there's the chip in the countertop, or there's the little burn on the part of the carpet in the back bedroom, note that at the time, because existing damage can't be charged for that. Also, there should not be any standard deductions to the security deposit. Now, if the lease agreement carves out something specific, this can get a little bit nuanced, but what that means is you as a landlord can't say, oh, well, every time a tenant moves, we have a standard $100 cleaning charge against the move out. You can't have that as a landlord in Colorado. Now, again, if the lease calls for something specific, it could be a little bit different, but there's no idea legally of a standard across the board, everybody gets charged this, because the concept is the security deposit belongs to the tenant. The goal of the landlord is to give all of that back to the tenant except for chargeable legal items to the property for damage and for things that are like this. Thirdly, you cannot charge for property improvements. So if the tenant does damage, let's pretend there was a light fixture and the tenant was playing inside and their kid swung the baseball bat and broke the light fixture. Can they be charged for the replacement of the light fixture? Yes, but you can't upgrade the light fixture. You cannot make any property improvements because of damage that was caused by the tenants. That doesn't just apply to light fixtures, it applies to everything. And then lastly is you cannot charge for wear and tear. Now this is where it gets very complicated because one person's idea of wear and tear may be another person's idea of damage. So just a couple things to keep in mind around wear and tear because it typically comes down to two items we find most common: paint and carpet. That's where it really comes into play. Now Colorado has a specific legal definition of what wear and tear is. We've done prior videos detailing wear and tear. We'll link to that in this, but the Attorney General for the state of Colorado has gone into more detail in the last couple of years to give us an even more specific, not just definition, but examples of what wear and tear is and what wear and tear is not. So one of the most common questions we get from landlords is a tenant moves out and a landlord says, well, gosh, that we have to charge the tenant for this painting. We've got to do some repainting. There's some scuffs on the walls. Well, one thing that the Attorney General for the state of Colorado has said specifically as it relates to landlords attempting to charge for paint was this: normal wear and tear to a wall or other surfaces includes but is not limited to. So they're saying we, the state of Colorado, we consider these things wear and tear and they may not be charged to a tenant's deposit. Normal wear and tear and other surfaces include but not limited to minor scuffs. So scuffs on walls cannot be charged, that's considered wear and tear. Or minor chips, if there's a chip on the paint, chip on the wall, that cannot be charged, wear and tear. Or superficial holes to painted surfaces, meaning when the tenant hangs up a picture and they put the little nail hole in the wall, that is not chargeable. That's not damage, that's wear and tear. Now, if there's a fist hole through a wall, that's different. But the Attorney General goes into much more detail. We're just trying to give a brief overview of some of the things as it relates to painting. Secondly, what about carpet? This comes up a lot as well. Gosh, the carpet was only a year old when my tenant moved in. They've been here for 5 years. Now the carpet looks really bad. Can I charge them for the replacement of the carpet? Well, a couple things to keep in mind. Number one, you can potentially charge your tenants for professional carpet cleaning if the lease calls for it. And then the tenant must be given an opportunity to have that carpet professionally cleaned upon move out themselves. So if the lease allows that and addresses it, that's fine. If the lease doesn't allow it and addresses it, then you can't charge for professional carpet cleaning. Now it gets very tricky as you're trying to figure out the life expectancy of carpet. In any charge for damages, the life expectancy of the item must be taken into consideration. Now what HUD would say, HUD gives some guidelines around expected life expectancy for carpet. Now they don't drill down to an exact amount of time, but what they say typically is life expectancy of carpet is going to be somewhere in that 4, 5, all the way up to 7-year range. But they get more nuanced. They say it also depends on how many people are living in the property. Is it a family versus, as HUD says, an elderly person, which is rather ironic because HUD also says we can't discriminate from a family to an elderly person. But there's different life expectancies, HUD would say, potentially, on how much usage that carpet is going to put in place. So it gets very, very nuanced as it relates to this type of a thing on what that life expectancy would look like. Now, what the security deposit return process is typically going to look like for you as a tenant is when you notify your owner landlord that you're going to be moving, they should give you some documentation as to what that process is going to look like and to their expectations per the terms of the lease and per Colorado law to help you get your deposit back. We believe that should be the goal of any legitimate and honest property management company and landlord, is we want to return your security deposit to you. So we're going to help you and tell you everything you need to do in order to get that full security deposit back. We're not in the business of retaining security deposits unless it's necessary per the terms of the lease agreement. So you're gonna move out of the property. Someone should do a walk through the property. Now, they don't necessarily have to do that with you. Colorado law does not state that you have to be there and present for that. But the person who does the walk and the security deposit disposition charges should be someone who's trained on this type of knowledge and understands the laws in Colorado. And then the last thing is simply this. All deductions to your deposit as a tenant have to be itemized. So that means if you're one of our tenants and there are charges for carpet, or there's a utility bill or a hole in the wall, we have to give you an itemization for those charges. We can't just send you a check for the balance and not tell you why. We have to give an itemized reason for each of the deductions that way. And then last thing, there should be a process for you as the tenant to dispute that. So if you move out of a property and there are charges that you think are unfair or incorrect, you should reach out to that property management company, and they should have a process for you to dispute those charges, because it sometimes can be nuanced, and certainly PM companies can make mistakes and say, oh gosh, we're sorry, we charged you for carpet cleaning, we didn't realize you had cleaned it yourself. Our mistake, we'll get that back to you. So there should be a process in place. Now, this is not legal advice. We're just scratching the surface this way. But if you as a resident follow these best practices, you should, if you're working with a reputable company, get your deposit back. And if you are an owner, investor, you should follow these best practices to get your deposit back. We're often asked if we as Grace Property Management, are we pro-landlord or are we pro-tenant? And we say with all sincerity, yes, we are pro-landlord, and yes, we are pro-tenant. And we've been that way since 1978, because we believe that when property management is performed with honesty and integrity and in transparency, it's pro-landlord and it's pro-tenant, and they all win. And it comes to security deposits as well if they're done appropriately. If we can be a resource, jump on our website, rentgrace.com. Happy to help if you're a tenant looking for property rent, or if you're an owner client looking to work with a professional property management company. Happy to be a resource.